Good afternoon, and thank you all for coming and for inviting us to come today. As she said, my name is Cheyenne Castilla. I'm General Counsel at the Florida Commission on Human Relations. Most of the time, you're going to hear me either say Commission or FCHR, and that's what I mean. It's quite a mouthful, actually. So, as she said, that's David Organis. He's our Assistant General Counsel. He and I have both been there for, I think, 10 plus years. So hopefully when we get to the end, if there's any questions that you have, we can address them, and if not, we certainly can get back with you with the answer. And so I guess let's get started. As she said, we're going to be focusing today mostly on the considerations taken into account when we're investigating claims of discrimination. I will preface it and say we treat every claim basically the same, whether it's by a state employee or a private employee. Basically, it's going to be the same investigation. We're impartial. We don't give any consideration to, this is a state employee, we're going to give them, some kind of consideration, or this is an agency, we're going to give them the benefit of the doubt. It really doesn't come into play at all. So we'll see what we can get into with this. Hopefully you all have heard of the commission before. We hopefully prevent unlawful discrimination, make sure people in Florida are treated fairly and have equal access to opportunities in employment, housing, public accommodations. We try to engage in education and outreach like today, and just to spread the word about human relations in the state of Florida. As I said, there's basically 4 types of cases we cover. Employment is just one area. We also cover housing and public accommodations, which is another big unit within our agency. And as you can see, these are the bases that are covered in each of the topics we're going to discuss today. These may be different than local or other municipalities' coverage, but this is the coverage here in the state of Florida. And it could be any type of adverse employment action. Here's some issues that may come up that we investigate, but this is, not a inclusive list by any means. And when David gets up, he will discuss then the whistleblower and what is included in that act. So basically there's 2 ways to prove a case of discrimination. It can be established through either direct evidence or circumstantial evidence. And I'm sure you can understand what direct evidence is. Basically, it's put out there. The reason for the adverse action is, they may even say, we don't hire Hispanics here. We don't want to work with someone who's black. I'm not going to accommodate your disability, something like that. I think that's very rare. We typically don't see someone do that, and I hope that means we're going in the right direction, that they're not going to be that blatant with their discrimination. But there is still discrimination, and we have to show that through circumstantial evidence. So where there is no direct evidence and we're proving it through circumstantial evidence, there's a burden shifting analysis that is done on each case. So first we're going to see if the complainant can meet the elements for the particular case, and those are going to vary depending on the type of case that we're looking at. And I'm going to go through some examples to show you that. If the complainant is able to establish those, then we next go to the employer or the respondent and ask them what were the legitimate non-discriminatory reasons for the action that you took. Once we have that, if they provide one, it goes back to the employee or the complainant again to say, okay, here's the reason given. Was that a pretext, or was that a unbelievable reason? Was that a made-up reason? And so that's kind of the back and forth that we go through. So the first example I have here is your kind of generic disparate treatment claim. The first three are typically pretty simple to prove, especially for a person who already has a job within the agency. Basically, everyone is a member of a protected class, some protected class, be it because they're male or female or whatever race they belong to. They may belong to any number of religions or have no religion. And so that there is just basically to have them identify what it is they think they were discriminated against because of. Then they will have to, indicate what they feel the adverse action taken against them was, be it termination, the litany. It could be any number of things. Qualified is your minimum qualifications for the position. If they've already held the position, they're probably qualified. This would come into play more for a failure to hire case, maybe. And so number 4 is where things start to get more meaty, I guess, more interesting as far as the investigation is concerned. Typically, the FCHR will start out by, if they haven't already, they'll interview the complainant and ask them, are there any other employees around that you feel maybe engaged in similar conduct to you but were treated more favorably? Like if you engaged in some kind of misconduct and were terminated, and then this other comparator did the same thing, but they just got maybe a written or oral reprimand, and they're of different races. So a lot of times complainant may be able to identify those people for us. Sometimes they can't, sometimes they don't know, and so we'll have to dig a little deeper into those. And in that situation, the FCHR will ask the employer to provide documentation showing maybe how other, recently terminated employees were treated, what it was that happened that got those employees terminated, whether they were actually similar to complainant. And so there's a lot of dynamics that go into whether they're actually similar, what their job is, what their duties were, who the supervisor was, what actual misconduct they engaged in, maybe the frequency of that misconduct, the type of progressive discipline that was engaged. And so then basically we'll compare those two if we have an actual apples to apples type of comparison that we can look at. So what I've done is come up with a few examples. These are old cases from, I think, probably 9 years ago. And there shouldn't be anything that can identify who I'm talking about, but these are real cases. And I was just kind of going to go through and say what evidence we found, what the respondent said, and maybe help give you some pointers as how to do better from the employer's perspective. So in this first one, we're talking about a race discrimination case. Complainant received an oral warning for late deliveries on 2 occasions. Then on June 3rd, complainant allowed his truck to run out of fuel and was terminated for gross misconduct. Comparator 1 was also terminated for gross misconduct due to destruction of company property. He first rear-ended another vehicle with a company truck and was found to be at fault. No action was taken other than to state that the next accident would result in termination. He again caused a collision with another vehicle and was terminated. A second comparator collided again with a building with a company truck. He was at fault, but no action was taken. He then left the back of his truck unlocked, and 87 pounds of product was stolen. And then he was terminated for gross misconduct. So they're all delivery, they're all driving the truck, they were all terminated for gross misconduct. So maybe in your own minds you can think about, okay, so what should the employer, what might their legitimate non-discriminatory reason be, if there is one, and what kind of documentation should they provide to the FCHR? Because those are the kind of things, if you get a complaint from the FCHR, that's what's going to come up for you. What do I need to provide to try to get a no-cause determination? Well, in this case, there were no examples of warnings provided to the complainant. They said that they received complaints from customers, but they did not provide any documentation. Respondent asserted that the failure to refuel the truck was inexcusable and costed in excess of $1,000. However, the documents showed that that misconduct was no greater than the other two misconduct, even though respondent was trying to say that it was. So what the investigators and attorneys are going to be looking at is your story that you say lining up with the documentation that you provided? And if it's not, that's when the pretext is going to start coming into play, because it's just not believable at that point. Another common case that we'll see is a failure to accommodate claim. There's a lot that goes into determining whether an employee has a disability or not, and I won't really get into that too much here today. From the FCHR standpoint, we're going to try to get documentation from a doctor that's going to establish whether or not there is a disability there. Now that may be different from the information that was provided to the employer at the time the accommodation was requested. But for our perspective, we're just trying to determine if in fact there's a disability, basically. And so that's where the issue of what's known to the employer and those kinds of things are going to come out in that investigation. Second is whether they're qualified to perform the essential duties with or without an accommodation, and then whether the employer refused to reasonably accommodate. Basically, if an employee cannot perform the essential functions with or without an accommodation, then he is not qualified. And a protected employee is not entitled to an accommodation of her choice, but only a reasonable one. So when you're making your position statements to a claim of discrimination, those are some of the things to keep in mind, that these are what the FCHR is going to be considering in making its determination. The example I came up with, and you're going to start to see a pattern here with these, I'll just tell you up front, all of these were cause cases. Every single one of these was cause cases. So in this situation, complainant was disabled and respondent didn't disagree that there was a disability there. So complainant made a request for a reasonable accommodation for some software on May 8th. Some communication went back and forth, but the last email sent was then on June 8th. Still nothing had been done. Another month went by without any communication, nothing happened, and then complainant was terminated on July 17th. We went through the whole investigation process, and employer refused to provide documents to support the decision to terminate. And so that's really, I think, the tripping point for many respondents is, I think I'm right, I think I'm going to terminate you, but where's the documentation? You may even say your reason for it, but if you don't have a documentation for it, it's going to be difficult for the FCHR to support that. Another common claim we see, it could be sexual harassment claim, either by a supervisor, by a coworker. These are going to become, these are some of the more difficult claims, because typically a harasser is not going to engage in this kind of conduct while there's a witness, if they're smart, I guess. But so we're looking for the evidence to show that there's some kind of discriminatory intimidation or ridicule that's severe or pervasive enough to alter the conditions of employment. So we're looking at the severity of the conduct, whether it was physically threatening, humiliating, whether it was maybe just words or if it was touching, and all of those things. And where a supervisor engages in it, it's going to be different than where it's a coworker. So there's going to have to be, if it's just a coworker, we're going to look and see, did they report it to someone high enough to do something about it? And then once it was reported, what was done, if anything? So I have had several examples. I picked this one. Hopefully it's not too unpleasant for anyone, but in this situation, complainant was subjected to touching by the company's owner approximately 59 times during her 9 months of employment. There were massages, patting on her body, and he stood close to her so his body touched her. She became clearly distraught and distracted and began having trouble performing her duties. She was then terminated by this owner after she refused to consent to a sexual relationship. So again, if you're in this situation where you have a supervisor doing this kind of thing and you have to think about, okay, what kind of response are we going to put together? You might think in your own mind what you could say, knowing here what elements the FCHR is going to be looking for. As I told you, we do conduct witness interviews. We do accept affidavits from folks. And sometimes, such as these situations, it's hard to get somebody to come forward. In this case, we were able to get somebody. We had witness statements. While the owner denied what happened, weighing of the evidence we did have, it just showed that it more than probably happened. So we found cause here. Finally, I'm going to talk about retaliation, and this is a little different. This is not like a whistleblower retaliation. This is just regular retaliation, where someone either opposes something that's unlawful, or maybe they participate in an FCHR investigation, something to that effect, and the employee becomes aware of that activity and takes adverse action against them within a short time after finding out. So in this situation, we had a complainant who filed a complaint. I won't say who they filed a complaint with. It just says filed a complaint on June 27th. Complainant was demoted and moved from an office to a cubicle. Complainant made another report of religious discrimination and harassment on September 30th and was terminated the same day. So again, as an employer, what type of information could show that the employer had a legitimate non-discriminatory reason for its actions? I guess what caught me right up front was who was this reported to and who knew about the first one when these actions took place. Maybe something to look into. In the real case, respondent alleged that the complainant quit, or if he was terminated, it was for being insubordinate and disrespectful. There was a witness statement that complainant walked off the job, but then a sign-in sheet provided indicated that complainant was fired. So, the respondent being unable to provide consistent statements of what really happened is really what led to their downfall, I think. So when you're dealing with these adverse actions, from the beginning, when it looks like, maybe we're going to have to end up terminating this person, look at the documents that you're setting up that's gonna lead to maybe an investigation, and are they consistent? Are you sending the same message? Are there any documents? Because that's bad too, to make sure that there are documents supporting what you're doing and why you're doing it. And so with that, I think I'm gonna hand it over to my colleague. Thank you.
Hello, I'll put that there. I'm David Organis. I am the Assistant General Counsel with the Florida Commission on Human Relations. I've been in that position for almost 2 years at this point. And then I've actually been working with the Commission in various capacities since 2006. Gosh, when was that? I think October 2006. So at any rate, during this year, it will be my 10th year there. So, yes, thank you, Cheyenne. And so this portion will be focusing specifically on the Public Employees Whistleblowers Act. It's currently, there are some pending amendments. Our agency is not sponsoring those, and we're really not involved in that process. If these were to actually be passed, it would have an impact on how our agency investigates those kind of claims, and it would have a big impact for the people filing complaints, more I think than anybody else. But as I said, we don't really have any involvement in that. It is something I think to keep an eye on. I'm not sure really what the progress of that legislation is at this point in time. But so this will pertain to the Whistleblowers Act as it's currently written, and I would think that at least for the foreseeable future, this is what it will mean and what it will involve. So the Public Employee Whistleblowers Act prohibits agencies and covered independent contractors from retaliating against persons because they have engaged in protected conduct as it's defined by the Act. I put in here retaliating against persons as opposed to employees because, again, as the Act is written right now, it does provide protections in some situations for people who are not actually employed by or former employees of a state agency or covered independent contractor. Though the situations where that would actually come into play are probably very few. So what is an agency? An agency is any state, regional, county, local, or municipal government entity of the executive, judicial, or legislative, can't talk today, sorry, after lunch, legislative branch. It would also include any public school, community college, state university, or political subdivisions of those. So an independent contractor for the purposes of the Act would be any entity other than an agency that's entered into a contract with an agency to provide services on behalf of that agency. For FCHR's purposes, we're investigating claims brought against executive branch state agencies and independent contractors of executive branch agencies. So who are protected persons? Actually, this is more of an outline at this point, sorry. Protected persons, protected conduct, exceptions, and adverse actions. And then relief. These are the various sections of the Act, and this is what I'll try to cover in the next few minutes. I want to leave time for questions, so hopefully I won't move too fast. So, who are protected persons? Anyone who's been subjected to an adverse action by an agency or independent contractor in retaliation for engaging in protected conduct as defined by the Act. It could be employees. It could also be non-employees in certain situations. So for employees, we're talking about current or former employees of an agency or an independent contractor who either make a protected disclosure or participate in an investigation conducted by a state or federal government entity. It could be their own agency, it could be another one, but it would need to be a state or federal government entity conducting whatever this investigation, hearing, or inquiry is, and who refuse to participate in any adverse action prohibited by the section, or initiate a complaint through the whistleblower's hotline or the hotline of the Medicare Fraud Control Unit, or who file any written complaint to their supervisory officials, which could include an email, or submit any complaint to the Chief Inspector General, an agency inspector general, or whatever personnel is designated as an agency inspector general, or to the Florida Commission on Human Relations. For that last type of complaint, it could be in writing or simply verbal. And again, this is, as the Act is currently written, this is sort of condensing the plain language of the Act. So non-employees can be protected in certain situations too. A protected non-employee for the purposes of the Whistleblowers Act would be any person who makes a protected disclosure or participates in an investigation conducted by a state or federal government agency, who refuses to participate in an adverse action under the section, who initiates a complaint through the whistleblower's hotline or the Medicaid fraud hotline. Actually, let me go back to that. So what's missing from here is that would be a protected activity for employees is that element of making some kind of a complaint in writing or making a complaint through the supervisor. So if it's a non-employee who's trying to file a complaint, they would have essentially had to make an actual protected disclosure or participate in one of these types of activities here. There's more protections for actual employees as opposed to non-employees. So protected conduct. There are disclosures, and there are other protected activities. So a disclosure is a specific type of action that the person has engaged in. The person has to report actual or suspected gross mismanagement, malfeasance, misfeasance, gross waste of public funds, suspected or actual Medicaid fraud or abuse, or gross neglect of duty. The reported misconduct has to have been committed by an employee of a state agency or independent contractor. A disclosure has to be made in the form of a written and signed complaint, and it must be made to a state or federal government entity with the authority to investigate the misconduct complained about, which would include the Chief Inspector General, agency inspector generals, the Florida Commission on Human Relations, and the Whistleblowers Hotline. It also has to be made on the person's own initiative. It can't be part of their regular job duties or something that they were in some other way induced to do. They have to come forward of their own volition to make this disclosure. But there are also other protected activities, which is a sort of amorphous and general category contained within the Whistleblowers Act. In that situation, we're talking about any person who is requested to participate in an investigation, as previously discussed, or refuses to participate in an adverse action, initiates the complaint through the Whistleblowers Hotline or the Medicaid Fraud Unit. Again, an employee who files a written complaint to their supervisory officials or submits any complaint to the Chief Inspector General, Agency Inspector Generals, and Florida Commission on Human Relations. Those kind of complaints do not have to be in writing. They don't have to be signed. So those were the two general categories, well, the two categories of protected activities. And again, disclosures are very specific as to what complainant has to do, but then there are these other sort of amorphous types of protected conduct. And I think that's probably where everybody gets more confused. I think it's where the people wanting to make a whistleblower disclosure get confused, people who feel like they've been retaliated against for any number of reasons, and I think it's where state employers also get confused. Also, with the internal inspector generals, they almost always seem to focus on the first and specific category of protected disclosure and not on a lot of these other things that a person, especially an employee or former employee, might do, which, while not technically a disclosure, could still be considered to be protected conduct under the Act. There are some exceptions, though. A person can't report information that they know to be false. That wouldn't be a protected activity. The person complaining can't have intentionally participated in the violation in question. The complaining party can't currently be in the custody of the state correctional system or have been in custody of the state correctional system at the time of the incidents that they reported. What are considered adverse actions under the Whistleblowers Act? There's adverse personnel actions. Those would apply to people, obviously, who are current employees. Termination, suspension, transfer, demotion. Essentially anything that's going to have a negative effect on the terms and conditions of that person's employment. Adverse actions that affect a person's rights or interests. Those could apply to an employee or a non-employee. They're not limited to employment actions. And essentially anything that would be likely to deter a reasonable, similarly situated person to the person making the complaint from engaging in protected conduct under the Act could be considered an adverse action that affects a person's rights or interests. Relief under the Act, it's dependent on the circumstances, but it could include any of the following things. Reinstatement, which is something that seems to be very common with a lot of people filing whistleblower complaints with our agency. They're often looking for reinstatement to the position they had been terminated from. Back pay, reasonable front pay, reinstatement of fringe benefits or seniority, compensation for lost wages, benefits, and other expenses, attorney's fees, injunctive relief, and injunctive relief, sorry. So I had some scenarios prepared. They would be better if we were actually able to have a more of an interactive process, but I'll go through these, and then if we have some time, then I could open it up to questions. Actually, looking at the time, is this a point where if we're going to open it up for questions, we should do this now? 20? Oh, okay. I wasn't sure what the crossover time was. Okay, thank you. I'll go through these scenarios, but I guess if any questions come to you all during them, hold on to them, and we can go back and discuss them a little bit more at the end. So in the first scenario, complainant is an analyst employed by the Florida Department of Revenue. Complainant voluntarily submits a written, signed complaint to the Office of the Inspector General, alleging that an official intentionally misappropriated $100,000. Department of Revenue subsequently initiates its own internal investigation and requests the complainant make a statement. Both the IG and DOR investigations are ultimately inconclusive because there's insufficient evidence of intentional wrongdoing. So the first question is complainant an employee? In this scenario, it's pretty obvious complainant is an employee as the Act defines it. Complainant is employed by the Department of Revenue. Was there a disclosure? Yes, it appears in this scenario that there is a disclosure. Complainant voluntarily submitted a written signed complaint, and the subject matter appears to be what's anticipated by the Act. In this case, a misappropriation of a fairly considerable amount of money. Was there other protected conduct? Yes. The internal investigation conducted by Department of Revenue would also be a protected activity for the purposes of the Act. And I actually see a lot of situations where that gets overlooked. Oftentimes in the responses provided by the agency, they may address one protected activity but not another. I think it's sometimes because the agency inspector generals are much more focused on the issue of a protected disclosure and not other things that might have taken place in the office, and they don't often think about the fact that their own investigation could be a protected activity for our agency's purpose in investigating a whistleblower complaint that might grow out of something that occurred within the agency. I would like to mention that something I often see too from complainants, especially from attorneys representing complainants, also sometimes from agency representatives, is this idea that complainants have whistleblower status. And a particular phrase gets used. I'm not exactly sure where it comes from, but I think it's very misleading because the way the Act is written, there's no such thing as whistleblower status. You either have engaged in protected conduct for the purposes of the Act, or you haven't. If you're retaliated against as a result of that protected activity, you might have a cause of action. But there's really no one single point where a person attains this whistleblower status. So it's something that I feel like often both sides will rely upon, but it's really not a very accurate way to look at this situation. Because I'll see responses that say, we didn't feel that this was a protected disclosure, so this person wasn't viewed as having whistleblower status. And I think that that is a mistake, especially from our perspective investigating these complaints, because that more amorphous and general category of protected activity is being overlooked, but it could end up resulting in a cause finding, especially if those allegations aren't sufficiently addressed in our investigation. Here, what was interesting is there wasn't actually an adverse action. So a scenario like this, although complainant has definitely involved in protected activities, we don't have any indication that at this point complainant has actually had anything done against them. So the second scenario is a little bit more complicated. Here, complainant is an administrative assistant employed by PPM Corporation, which is a private company that provides prison management services to the Florida Department of Corrections. Complainant is interviewed by an inspector at Department of Corrections as part of an internal investigation. 2 months later, Department of Corrections publishes a report and identifies complainant as a witness, PPM Corporation, the private company, then terminates complainant's employment a month later. So is complainant an employee? Here, complainant is not an employee of Department of Corrections, but complainant is an employee of a covered independent contractor. Was there a disclosure? I would say no. In this situation, there's no indication that complainant made the type of complaint with meeting all of the criteria described by the Act, so no, I would say there is no protected disclosure. But was there protected conduct? I would say yes. Complainant was interviewed by an inspector with the Department of Corrections as part of an investigation they were conducting. That would most likely be a protected activity. What if the investigation was conducted by PPM's Human Resources? That's kind of open to question because the complaint, here isn't a complaint, but here the investigation that's being conducted is not being conducted by the Department of Corrections. There's definitely an issue there about, is that a protected activity? I would say actually no, because the investigation is not being conducted by a state or federal government entity. So is complainant a protected person under the Act? In this scenario, I would say yes, because they're employed by a covered independent contractor and they engage in a protected activity when they're part of the internal investigation at Department of Corrections. Who is liable? Again, that's a more complicated question. I'd say that PPM is definitely going to be liable, even though it's an independent contractor. Depending on the circumstances, though, Department of Corrections may also be open to some form of liability because they contract with this private company. Well, yes. I mean, I think in this situation, what the implication is that she is terminated because of that participation, but really this is getting more at not ultimate liability, but just a prima facie case. So I'm glad that you said that, and it probably didn't get picked up for the purposes of the recording. But the question was, is complainant terminated as a result of the protected conduct? That gets into a further inquiry that will have to happen in any of our investigations. And these scenarios are geared more obviously toward establishing a basic claim and not getting into whether or not the agency has a legitimate reason for what it's done. But obviously, everything does ultimately turn on that. First, can it be established if the complaining party even has a basic claim for whistleblower retaliation? If it does, then obviously what our agency will be looking at is what's the response provided by the employer or former employer, and what was the reason why they took whatever the action was? Is there documentation, and what is the documentation to support whatever reasons they're providing for any adverse actions that might have occurred? So just because these things happen in close proximity, let's say, it doesn't necessarily mean that the complaining party will ultimately prevail, but it does mean that we're now at the point where the agency is going to be required to provide some sort of explanation for why whatever occurred did occur from their side of the situation. So in the third scenario, complainant is employed by Florida Fish and Wildlife Conservation Commission. By the way, I probably should have said before starting into the scenarios that I derived all of these from actual cases that we've had. I threw in the names of actual state agencies, though none of them have any correlation to what takes place in any of these scenarios. So on the off chance that anybody works for any of these agencies and was trying to rack their brains for whether they were involved in this, you almost certainly weren't, because I mixed everything up. But for the sake of making it's too difficult to try to come up with fictitious names for state agencies, so I apologize if anyone felt implicated in something that they were actually not. But so in this situation, complainant is employed by Florida Fish and Wildlife as a marine mechanic. Complainant emails a complaint to a direct supervisor asserting that a coworker is creating a hostile work environment. The coworker is a family friend of the supervisor. A week later, complainant is disciplined for tardiness under a policy which is rarely enforced. So is complainant an employee? Yes, here complainant is an employee. Was there a disclosure? No. I would say there does not appear to have been an actual disclosure in this case. What was complained about does not meet the definition for a disclosure, and the form in which complainant complained is also not a disclosure. But did complainant engage in other protected conduct? I would say yes, in the sense that complainant emailed a direct supervisor to make an actual complaint. Anything like this is going to be extremely fact-specific, but the wording of the statute is very, it's very clear on the plain language, though it's somewhat confusing as to why some of these things are so broad. But just based on how the statute itself is written, yes, an email is in writing, and if it's made to somebody's supervisor, that would probably be protected activity. Now, what if the report was not made in writing? I would say then complainant has not engaged in a protected activity. What if complainant reported harassment in an open meeting? I've actually seen this situation a lot, that the basis for a retaliation complaint with our agency is something that took place in a meeting. Again, no. Based on how the statute is written, simply an oral report of something, even if it's made in a public setting, is not going to be a protected activity.